Start. Para. In the impugned order, while dismissing application under Order 9, Rule 13 CPC, the learned rate controller, broadly speaking, traversed through three aspects. It was held by the learned rent controller that the eviction order dated 27/5/2009 was not an ex parte order since the legal representatives other than the present appellants of late Sri Subhash Gulati had contested the eviction proceeding, and since the present appellants had inherited the tenancy as joint tenant with the contesting had inherited the tenancy as joint tenants with the contesting legal representatives, there was no need to bring them on board, especially because even according to the present appellants, they had been disposed from the demised premise. Secondly, it was held by the learned rent controller that there was no error in service of notice of eviction proceeding under Order 5, Rule 20 CPC. Thirdly, it was held by the learned rent controller that even according to the case set up by the present appellants, they were aware RCT number 13/2018 Atul Gulati and others versus Varsha Mehra and others, page 7 of 24, page about the eviction proceeding on 7/9/2012 itself, when a settlement was recorded amongst the legal representatives of the late Sri Subhash Gulati, and that being so, the application under Order 9, Rule 13 CPC, filed on 4/3/2017, was hopelessly time-barred in view of Article 123 of the Limitation Act. Para. During argument, learned counsel for appellants took me through trial court record and contended that the impugned order is liable to be set aside. It was argued on behalf of appellants that the view taken by the learned rent controller that the present appellants were not required to be heard is in violation of principle of natural justice of right to be heard. It was submitted by learned counsel for appellants that the remaining legal representative of late Sri Subhash Gulati kept the applicants in dark about pendency of eviction proceeding. It was further argued that in the absence of formal application under Order 5, Rule 20 CPC, the learned rent controller could not have proceeded with substituted service of notice by way of publication, and even the publication of the notice was carried out in National, which is not a national level newspaper and is hardly read by anyone. Learned counsel for appellants also submitted that appellant number 1 was disposed from the demised premises in August 2002, and thereafter he avoided going to the shop, since whenever he tried to do so, he was forcibly restrained by respondent number 2 and 3 and their agents by way of involvement of local police and SDM, and that was the reason for non-availability of appellants in the demised premises at the time of visit of RCT number 13/2018 Atul Gulati and others versus Varsha Mehra and others. The process server, it was also argued on behalf of the appellants that there is no explanation as to why no effort was done to serve the notice of the eviction petition on appellant number 1 at his residential address before proceeding with substituted service by way of publication. It was further argued by learned counsel for appellants that the settlement deed dated 7/9/2012 did not mention about the judgment, and the decree dated 27/5/2009 and appellate order dated 9/11/2011 So, limitation to file application under Order 9, Rule 13 CPC could not be computed with effect from 7/9/2012. Stop.